A very good morning, good afternoon, and good evening to you, depending on where you are joining us from. Thank you for taking time to join us for today's webinar. My name is M. Hakim and I am with the Singapore International Commercial Court, more commonly known as the SICC in legal circles. Today, we have an exciting panel discussion lined up on third-party funding at the SICC, a webinar to explore more options for dispute resolution at international commercial courts, but with particular focus on the SICC, of course. Just a little housekeeping before we get started. If you have any questions during the panel discussion, please type them into the Q&A tab on your Zoom control panel. The moderator will bring them up during the session as appropriate, or when we have time for questions at the end of the panel. We are also recording this webinar and shall be sending you a link via the email you had used to register should you wish to review certain segments. We are also making it available on SICC's YouTube channel. Without further ado, I will turn the time over to Ms. Sheila Ahuja, our moderator. Sheila is a partner in Allen & Overy's Global Arbitration Group based in Singapore and the joint chair of the firm's India Group. She is also a registered foreign lawyer with the SICC. Her experience spans jurisdictions such as Hong Kong, Singapore, England and Wales, India, Japan, Myanmar, Thailand, and the PRC. Sheila has particular experience of energy and infrastructure disputes, disputes arising from joint ventures and distributorship arrangements, and disputes relating to complex financial products. She speaks English, Hindi, Sindhi, Cantonese, and Mandarin. But for today's webinar, she will limit herself to English. Sheila, please.
Thank you very much, Hakim, for that introduction. I'm very pleased not to be quizzed in any other language. A good day to everyone. Thank you for taking the time to join us here today. And for those in Singapore, thank you for sparing some time on this lovely afternoon. On the 21st of June, the Ministry of Law here in Singapore announced that as of the 28th of June, Singapore will permit third-party funding of domestic arbitration proceedings in the Singapore International Commercial Court, the SICC, that were originated in the SICC, and also related mediation proceedings. This is obviously a significant development, particularly vis-à-vis the SICC. We have, of course, seen third-party funding introduced into Singapore a few years ago and with great success. This new development reinforces that success and gives way to new opportunities. And thus, what we are gathered here today to do is to discuss at this webinar third-party funding at the SICC, where we will explore in some detail what it means to go to the SICC and how the added value of having the ability to be third-party funded will see an even brighter future for the SICC. I will start by giving you a brief introduction to the panel. And as I have the pleasure of a panel that is so well known and regarded, and as you had detailed profiles put up front, contrary to my usual long-windedness, I'm going to keep myself short and spend more time diving straight into the questions. We have, first of all, Laurence Wong, who's the Senior Director of Business Development at the SICC, and whose key focus is to develop the SICC's engagement and awareness with lawyers and in-house counsel internationally, and establish the court as an effective and efficient dispute resolution forum. Next, we have Tom Glasgow, who's the Chief Investment Officer Asia at Omni Bridgeway. Tom manages its investment team and portfolio of funded cases throughout Asia, and he holds dual degrees in law and international relations, and was previously a member, I'm pleased to say, of Allen & Overy's International Arbitration Group in Asia. We have Laurence Tay, who's a senior partner at Dentons Roddick's dispute resolution practice and co-head of international arbitration. He appears regularly in court and in international arbitration as lead counsel, and he also sits regularly as an arbitrator. He's a member of the Singapore Bar and was also a member of the SICC Rules Subcommittee, who work on the rules of procedure of the SICC. Next, we have Vyapak Desai, who's a partner at Nishit Desai Associates. and the head of its International Dispute Resolution and Investigations practice, and a registered foreign lawyer with the SICC. Interestingly, Vyapak recently appeared on the One Take Show, a YouTube podcast series on law, logic, and life, where the podcast host described Vyapak's overview of arbitration in India as, and I quote, perhaps the most comprehensive conversation I've had on arbitration. So no pressure, Vyapak, but we'll be watching this space. And last but not the least, we have Cameron Ford, who's a partner at Squire Patton Boggs and has extensive in-house experience with construction and energy-related commercial arbitration proceedings. Cameron is a registered foreign lawyer with the SICC, and if all of that wasn't enough, he's also undertaking a PhD on security for costs in international arbitration. So I won't profess to be any expert on that topic, and we'll divert straight to Cameron if that comes up. And with that, let's dive straight into our questions so as to make best use of time. The SICC was formed in 2015, as we all know, and has made headlines in various contexts since, with its composition on renowned international and Singapore judges, and some of its groundbreaking jurisprudence has, of course, been the subject of much discussion. 6.5 years on, a good place to start on this talk, I think, would be to discuss where the SICC is at now. So if I can invite you, Laurence Wong, I'll keep taking the two Laurence's last names, just to be clear, Laurence Wong, to give us an update, if possible, on the status statistics of the SICC, and in particular, if you can focus a little bit on the arbitration-related matters in your overview. Thank you, Laurence.
Thank you, Sheila, and good morning, good afternoon, good evening to all on this session this afternoon. Thank you for joining in. Now, Sheila, as you said, since 2015, the SICC has been developing its caseload, and up to now, we have a total of 71 matters before the court, both with judgment and also in the process of it, right? It's been growing over the years. We started with only 2 in the year 2015 when we had. It's gone on to 6, 9, 11, 12. Last year, we had something like 17 cases. And this year, to date, meaning half the year is gone only, we are up to 16 really in that sense. So the numbers have been increasing. And not just the numbers, but also in terms of the nationalities. We now have about 39 parties from 39 different countries that have appeared or have matters before the court itself. Claims as low as 1.2 million Singapore dollars to even as high as about 1 billion Singapore dollars itself. So that's the way it's been growing. Not just while a majority of the matters have been matters that were commenced in the Singapore High Court and were transferred subsequently to the SICC, we've been seeing more direct filings with the court. And this is a consequence of time, I would say, because as you know, when the court started, you need parties to agree to have direct jurisdiction of the SICC in their contracts. And over time, you need those contracts to end up in disputes. Not that we want them to end up in disputes, but when they do, then that will still take time. And even when they end up in disputes, parties would still try to settle or mediate first before they even start any action in the court itself. So that's grown. You alluded to the second part of it, which is arbitration matters. So that was the other key development for the SICC too, that the legislation was amended to allow the SICC to be one of the supervisory courts for international arbitration-related matters, other IAA matters. And since that's happened, we've seen a few direct filings with the SICC, as well as some transfers over from the High Court. And that also has a sort of piqued interest of both lawyers as well as corporate counsel with the SICC, because you now have arbitration matters that have started in the, say, SIAC or ICC, so long as they are seated in Singapore, the applications come in and then they get heard. There's one interesting one I'd like to mention in terms of how fast it went. This was a matter called CJM and 6 others versus CJT. It was a recourse against an award. The originating summons was filed on 20th January 2021, and then the first CMC was heard on the 11th of February. It was transferred to the SICC in March. There were 2 very brief hearings before Justice Anselmo Reyes on the 21st of April and the 7th of April. And Justice Reyes issued his judgment on the 21st of April and the 7th of June, and Justice Reyes issued his judgment on the 15th of June, just 8 days later. So that's a quick turnaround time. And why parties like that, on the one hand, could be because you actually have an international judge giving perspective to the application, number one. Number two is an issue of costs, where the costs awarded within the SICC is on a reasonable basis, different from within the High Court. So that's how we've been developing. The judgments have been coming out. We've had 73 written judgments so far of the court, another 17 on the Court of Appeal. And the turnaround time is relatively fast for those judgments, at most usually about 3 months, if not shorter. In fact, the record is that besides the one I just mentioned, within 8 days, first other full trial first instance hearing was 2 weeks after the date of last hearing. So that's where the court is. I will talk more about it later in that sense, but just to give you a feeling of where we've gone. Thank you, Sheila.
Thanks very much, Laurence. And we'll come back to quite a few points you made there, which were really interesting, including the supervisory court rule development and, of course, the international judges aspect. But just with that background, as you put it very clearly, it just shows how much progress has already been made. And now with this new development announced by the Ministry of Law, that will surely be welcome news, particularly from the perspective of a third-party funder. Now, Tom, over to you as the third-party funder in this panel. Can I ask you to share your perspective on this development of the SICC allowing third-party funding, including the fact that the scope relates to origination matters in the SICC rather than transfer matters?
Sure. Well, thank you, Sheila, and thank you very much to the SICC for putting this on today and inviting me to participate. It's a pleasure to be here. I think it's fair to say that we enthusiastically welcome these new developments. And not only will it facilitate the funding of SICC proceedings, which is great for users and great for funders, but we also see this as a general endorsement of our industry and the manner in which we've been supporting users of dispute resolution in Singapore over the last 4 or 5 years. So to build on that, perhaps I can sort of start with what we see as the potential benefits of SICC proceedings from perspectives of funders and why we're interested in it. And then I'll come on to the second point, Sheila, on the decision to allow funding for cases commenced in the SICC only. So to the first point, as funders, it's probably no surprise to you that we're typically approached for the higher value, more complex and expensive cases. And in this part of the world, most of those cases really are international in nature. And I don't think it's controversial to say that the majority of those cases currently go to international arbitration. So it's really with that in mind, and I think conceptually, that I would say that we certainly welcome the opportunity to participate in SICC proceedings because they're a viable alternative to international arbitration. And I say that largely because there are shortcomings in the international arbitration system that can make it less attractive for funding. And I don't want to dwell on the issues in international arbitration. That's not the point of today's topic. But perhaps I can just highlight 3 areas where I think the SICC proceedings are likely to compare favourably, at least from our perspective as funders. First of all, and Laurence Wong alluded to this, as funders, we're naturally very focused on costs. International arbitration is expensive, especially when arbitrator fees and deposits are calculated on an ad valorem basis. And a significant proportion of that cost comes up front, especially in an institutional arbitration. And from a funder's perspective, that substantially increases our risk. So it's likely that I think that SICC proceedings might be less costly, or at least the cost is likely to be more evenly spread over the life of the case, which is attractive to us. Secondly, we're always looking for predictability of outcomes as funders. And that can be a challenge in arbitration. The nature of the arbitration community and the way in which arbitrators are appointed, coupled with the lack of transparency and accountability, does carry some risk of creative reasoning, compromise, and at times unsatisfactory awards. Now, I'm not saying that always happens, but it certainly can happen. And indeed, there are some funders, not Omni Bridgeway, but there are some funders that refuse to fund arbitration for that reason. And conversely, the SICC is transparent. Its judges are accountable for their findings on the merits, including by appeal. And for us, that's likely to mean greater predictability over the final outcome. And that's likely to mean we're more likely to fund, or possibly that we'll fund on more favourable terms, given the change in the risk profile. Lastly, we're very focused on timing as well. A swift resolution, whether that's by determination or settlement, is nearly always better from our perspective as investors. Arbitral procedures are increasingly drawn out, I think, because of due process concerns. Arbitrators are also less likely, I think, to dismiss claims early or to entertain summary procedures or even to indicate their initial views on the merits. And all of that reduces the prospects of parties being prompted towards a settlement. So judges at the SICC, like other courts, may well have more tools to assist in promoting the parties getting to an early resolution by settlement, or indeed by moving to a quick determination, as Laurence gave that example earlier. So in that sense, I think as a potential alternative to international arbitration, we certainly welcome the opportunity to fund SICC cases. That said, it still remains for the parties to elect that option. So the new rules only get us so far. We need people to actually bring these cases so that we can fund them. But it's certainly very interesting for us. Just to turn quickly now to the decision to permit funding of SICC cases commenced in the SIC rather than those that are transferred. I think it's important to give a little bit of broader context here on the position on funding in Singapore, because I think that can sometimes be misunderstood. Singapore law does not prohibit litigation funding or litigation funding arrangements per se. The case law is clear. It sets out the relevant public policy and the circumstances in which a funding arrangement is lawful under the common law. And the courts, of course, retain the right to hold those arrangements unenforceable if they don't comply with the relevant requirements. But it's not correct to suggest that there's a blanket prohibition on funding in Singapore. The case law is also quite clear that the 2017 amendments to the Civil Law Act and the regulations that have been passed around funding of specific categories of disputes, it's clear that they're not exhaustive. So the common law position still applies outside of that permissive regime. So I would say that under the right circumstances and in the right manner, it would be permissible to fund all types of SICC proceedings. The difference is that if one falls under the expressly permissive regime, there's less potential oversight of the funding arrangement by the courts. And I think that makes sense, just as it did in international arbitration. Where the parties agree to a certain process, they can be taken to have agreed to the rules that surround it, including any rules around the availability of funding. But otherwise, where jurisdiction is assumed by the court rather than through the parties' agreement, I think it's perhaps reasonable that you might see more oversight by the courts around any funding arrangement. And perhaps also in those circumstances, you might see a greater range and sophistication of the parties, again, justifying that approach. So overall, very welcome developments and excited to get involved. We are funding our first SICC case, which is a challenge on an arbitral award. We haven't yet had one which has gone straight to the SICC, but hopefully that will come in the near future.
Thanks, Tom. That's a really great overview, and in particular, just explaining the regime. I think there's a lot to be there's a lot of useful detail in there. I want to come back to two topics in particular, which are the cost point and the appeals point. But first, I want to focus on taking a step back and looking at Singapore as a jurisdiction. And Tom said right up front, this development that we're talking about today represents a general endorsement of Singapore as a dispute resolution forum. As we've seen over the last few years, Singapore has made great headway in that direction. Now, of course, it is a place that is widely reputed as a key hub for international commercial arbitration. So I want to look at it from that lens for a moment. And Cameron, if I can ask you, do clients or in-house lawyers in that sense here in Singapore actively consider the SICC as an alternative to Singapore arbitration? Or if I bring the two forum together, should the SICC be referred to expressly in contracts, for instance, as the supervisory court, going to the point Laurence Wong made in introduction?
Thanks, Sheila. It's a little difficult to assess what the majority or a majority of in-house counsel and clients are doing when you can't see, you have no visibility of the contracts. But it's reassuring to hear from Laurence Wong that there have been quite a few direct commencements in the SICC. I found when I was in-house that there is a lot of conservatism in clients and in-house counsel when it comes to changing templates. And I think that's the key when it comes to talking about dispute resolution, that clients and in-house counsel tend to follow what's in the template. Particularly if it's not their area of expertise. And if arbitration or local domestic litigation is in the template, that's generally what stays there, unless some disruptor comes along and forces or encourages people to change. So those disruptors can be people who are enamored of the SICC and for some reason trying to persuade their own organization to use SICC, and thereby they try to encourage other parties to do the same. Or I've found, and again, like Tom, I don't want to go into this too much here, but some clients who feel they've had a bad experience of arbitration, they'll be looking for an alternative, and SICC will be the alternative. I found where SICC was particularly useful was where a party in another country was insisting on litigation in their domestic courts. And it would be particularly the case with USA and even with Australia, where those parties felt they had a local advantage because of their connections and familiarity with the systems and unfamiliarity with anything else. And I found it useful to be able to show them and convince them of the benefits of SICC, particularly where their minds were closed to arbitration for whatever reason. And so show them, convince them of the merits of SICC. And that would be, you could go down to quite a bit of detail. You'd send them the website links and the profiles of the judges to show them that it was a truly international tribunal, that you'd have 3 of them on hearing, and that you had a right of appeal. No one thinks they want to appeal until they've lost, and that's the only then that's the only thing they think of. So that can be attractive at times. So I think getting back to the original question, it will take time for templates to change, for people to have experiences that make them more open to the SICC, and for just to gain more currency. And I see it not only as an alternative to or complementing arbitration, but even complementing local litigation. You might have Singapore companies with counterparties in close neighboring countries who've been able to use Singapore litigation for their dispute resolution. They also may prefer SICC for a variety of reasons. As to having SICC as the supervising court, I think that's a good idea. If you, for those who wish to stay with arbitration, my only hesitation is with people tinkering with arbitration clauses. They're already very problematic, and I can just imagine when someone who isn't completely aware of all the nuances beginning to talk about a supervising court in an arbitration clause. We've seen what happens when people tinker with arbitration clauses, and it makes things very interesting for us. So if if there's a good safe template somewhere with SICC as the supervising court, that would be great. Otherwise, do so with care, I think.
Thanks, Cameron. Laurence, Tay, can I ask you to add your 2 cents on that? Are templates here changing, or do you think that choosing it as a supervisory court would lead to more active, would lead to you appearing in more Singapore proceedings, arguing what the scope of the clause means?
Well, I think it's a question of growing a culture and getting into a habit of classifying the SICC as a supervisory court. In the initial stages, people would treat it with caution for the reasons that Cameron mentioned. There might be something that goes wrong in the draft, and you end up in an uncertain situation. But the moment, dare I say it, the SICC comes up with a model clause, the moment clauses work fine and the process has gone through without problems, then I think people will see the value of the SICC being a supervisory court, not least because its judges are familiar with arbitration, with the habits and the practices of international arbitration. And then you get a kind of certainty of expectation throughout, not just in the arbitral process, but also in any review situation, whether it's jurisdiction or on a set side. If I could add to what Cameron said a little bit about the take-up rate on SICC, I think it's also very much what Laurence Wong said. The numbers are increasing, and I'll come back to what I said previously. It's a question of building that culture and that habit of getting the parties to see or to view the SICC as a viable forum for dispute resolution. What I've seen, because I practice both litigation and arbitration, is that for most of the 20th century and before, countries were concerned about sovereignty, and that tied in to the closed nature of the courts. But now that we're into the 21st century, courts have never spoken to each other as much as they have in the last 20 years. There's more collaboration between courts. And in the meantime, in the 50s, what arbitration had was a real shot in the arm in the form of the New York Convention, and that continues to be the big selling point of international arbitration. You can enforce it under a, what is the best subscribed convention in the world. But I think we'll deal with this a little bit later on. I think the courts are catching up, but let's leave that to later on in the talk.
Thanks, Laurence, and you're quite right that we will come back to enforcement for sure. But just focusing on this point about choice of SICC as the forum in contracts, by sort of users of arbitration. Can I take the question to beyond Singapore? So Vyapak, can I ask you what you think? Is SICC gaining popularity outside Singapore? Whether in India, obviously, where you are based, or even elsewhere. Your practice is international. And in particular, do you think that now with the availability of third-party funding, which is of course a widely discussed topic in India as well, would it render the option of SICC even more attractive?
Sure. So I think, hope I'm audible. Thanks a lot, SICC and Laurence, for this invite. So I think my short answer would be, we treat Singapore, if we had to do a survey of to live in India, it would be possibly Singapore. I usually say that it's less stressful to do a day to Singapore than to Delhi from Bombay. So if you ask me, whether SICC will gain popularity in India, my answer would be emphatic yes. Reasons that so far as the jurisdiction is concerned, I think we already have got that comfort, right? Have so much of Indian law advice available. We have foreign, law firms like yours and others, where again we have a lot of, and in fact, law firms like mine and other law firms recently have even opened offices in Singapore. We are there for last almost 15 years. So I think from a comfort perspective, I don't see a problem of experimenting something which is new, obviously alternate to an alternate dispute resolution. This is the first time we talking about an alternate to alternate dispute resolution, but yes, why not? And there are, I think, a lot has been already discussed about SICC is good or SIAC is good. I'm not going into that debate because that is something which was possibly done before SICC was. But if you see the history, right, uh, uh, the cases which have been filed in SICC, and Laurence Wong can vouch, there are matters concerning Indian parties already. In case of Kiri Industries, which is widely debated and widely discussed on different forums, come out of Indian contract against another Chinese party seated in Singapore. And the judgment on valuations coming from SICC is widely read judgment. We also have our very good retired Indian judge from Supreme Court, Justice Sikri, sitting as international judge on the panel of SICC. So I think if you ask me a question whether this will be something that India will try, I would again, as I said, definitely yes. From other jurisdictions, again, I think Singapore has always attracted many other jurisdictions for international dispute resolution, and I don't see why SICC should not be also considered with all the pros and cons which comes with the court, whether it is confidentiality, whether it is joining of third parties, whether it is, obviously arbitration is also growing in that area. While courts have certain inherent advantages and inherent disadvantages. But coming to the topic of third party funding, again, I think Indians possibly even more progressive on that front. Were not allowed in India, and there is nothing which bars third party funding in India itself. So there is, from a law perspective, this is a great start. What is lacking in India when it comes to Tom evaluating Indian cases is the aspect of enforceability and recoverability, right? Nobody is worried about the legality of third party funding so far as Indians are concerned. So I think if in a right case, in a right factual scenario, if parties choose SICC now more access to third party funding compared to India, and of course issues of appeal and enforceability, we are talking little later, are taken care of as we progress. I think this will be a very, very important addition for people to consider one more advantage to take SICC. Again, nobody stops that from SIAC as well, right? So from Indian context, this was possibly one disadvantage which has been taken up. But now it is at par so far as this issue is concerned when it comes to SIAC. So there are a lot of, deliberations and ifs and buts, as Cameron said. Somebody has to really put a thought into this and disrupt the current scheme of things. Blindly people put SIAC when they want to think of international arbitration concerning India and some foreign party. So I think SIAC has some work to do there in terms of getting that support. But I am very, very hopeful and very positive about this development. So maybe we can discuss issues on appeal and enforceability as we progress.
Thanks, Japak, and thanks also for alluding to the enforcement point, which I'm going to call on you to discuss in a moment, just as a hint. But just before that, and Tom mentioned right up front, one of the benefits of course, the International Commercial Court being a court is appeal and accountability. I think, Tom, is how you put it, and I think that is one significant advantage akin to courts in general, that there's an inherent right to appeal when you receive an SICC judgment that you want to question. And of course, as things stand here, international arbitration awards are final and binding and not subject to appeal on the merits. And even when awards that can be appealed in other jurisdictions, it's of course normally confined to the point of law of the seat of that award. So my point is, where are we on this appeal question? And I want to go back to you, Laurence Tay, and ask you, does the right of appeal help tip the balance, do you think, in favor of the SICC?
Thank you. Let's recap where we are on rights of appeal. A couple of years ago, there was a public consultation by the Ministry of Law inquiring into whether the community would like to have enshrined in statute a right of appeal by agreement. There was a proposed new Section 24A of the International Arbitration Act to make that clear. The last time I looked, that hasn't found its way into actual legislation in Singapore. But even without the introduction of the new Section 24A, there is currently a way in which to have or to possess a right of appeal in an international commercial arbitration case, and that is under Section 15 of the International Arbitration Act, where you can opt out of the no appeal regime in model law, in which event you then come under the regulation of the Domestic Arbitration Act, which has a leave to appeal regime. I can call it a right of appeal. It's a leave procedure, and so parties can opt to have that appeal. I'm quite attracted to what Tom said earlier, that some of the, if you pardon the expression, some of the diseases of international arbitration concern a lack of transparency and accountability, and the long drawn procedures. I have said in other events that if international arbitration does not address and solve these issues, it will collapse of its own weight. And then perhaps it doesn't really matter whether you have the right of appeal or not. Commercial parties will then look to other more reliable forums, Singapore International Arbitration Center, Singapore International Commercial Court being one such forum. And just to address your question, Sheila, very often parties want a right of appeal so that they're not constrained to find ways out of a bad result by expressing it purely as a jurisdictional dispute or some sort of due process complaint. It has been suggested to me recently that a lot of the due process paranoia that seen in international arbitration nowadays is precisely because there is no appeal against the merits of what the court found. So a right of appeal can have its attractions, just perhaps not in the immediate intuitive way that people familiar with court processes might acknowledge or might sense.
Thank you, Laurence. That's a very interesting perspective. I actually want to now turn to still focused on this SICC judgment and recourse to it. I want to go back to outside Singapore, and Vyapak, if I can ask you, and I'll then ask Laurence to speak to this as well. Laurence Wong, sorry. How does the SICC square in terms of enforcement? Bearing in mind, of course, that where arbitration is concerned, as was mentioned earlier, the New York Convention does a good job of enabling this high degree of enforceability of arbitral awards. So what does the SICC enforcement perspective look like from your perspective, Vyapak? And then Laurence, you can tell us what the framework of enforcement is actually like for the SICC judgments.
So, so far as India is concerned, unlike the New York Convention, we only have countries notified for reciprocal arrangements on enforcement of judgments, right? And to our surprise, there are many important like US also not forming part of that list. But the good news is Singapore does fall part of that list, and also Singapore is the supervisory court recognized as part of reciprocal arrangement. So again, this is something to test at some point in time in Indian courts. But my initial view without going into too much of technicalities, that so long as SICC is set up as an arm of the High Court, it is formed. I really don't see a problem when it comes to enforcement of judgments passed by SICC is concerned in India. Of course, as I said, this is yet to be tested. Unlike the almost certainty when it comes to foreign, and at least in last 3 to 4 years, Indian judiciary has given a very clear mandate, and the kind of enforcement which has happened in foreign awards is, unparalleled for even any other jurisdiction compared to India. My sense is it should not be a big challenge. One can take recourse to what we call as Section 44A, which automatic reciprocal arrangement for enforcement of foreign judgments, and SICC should be considered as part of that mandate. But this is something we can look at as we move further. Otherwise, you can always take the judgment and file a suit using that as a summary procedure to say this is a prima facie evidence. So that is one very, very strong avenue, in my view, available for SICC court as well. But of course, not as clear as foreign awards under New York Convention. And only on the point of appeal, I'll just take 30 seconds more. I know there are a few things to be covered. See, from an Indian perspective, right of appeal actually may be a very good attraction compared to no right of appeal. In an arbitration scenario, we are very used to challenges becoming almost like an appeal. Okay, I think Indian parties and Indian counsels or lawyers are not averse to challenges or appeals, right? They are okay. In fact, getting that one right of a bad idea to actually sell it better than arbitration, considering the Indian mentality. I think what is important is the timelines, right? One sees that whether it is an appeal or not, so long as the timelines are not going completely out of control, it can be actually advantage rather than a disadvantage if you look at it from that perspective. But otherwise, I think every party choosing and dispute resolution obviously wants more finality and more certainty than right to appeal. So that debate continues. But if someone wants to really, really disrupt, I think there is a nuance attached to this right of appeal, so long as we are able to do it in time.
Thank you. That's very interesting from your perspective. And in particular, of course, India is one of the few jurisdictions that doesn't actually recognize all the New York Convention states either, unless they're notified by official gazette. So actually, it's a brilliant comparator and gives, I think, a real run for their money when SICC comes to the table of options. But speaking of the regime of enforcement, Laurence, Wong, can I ask you to actually respond to Vyapak's? This is great because you can just ask each other now and I'll stay on mute. But you raised this point about, depends on the scope, Vyapak, and I think it's a very good point. So Laurence, Wong, can you tell us what is the sphere of enforceability of SICC judgments?
Certainly, Sheila. And the Vyapak, I guess the first one is that I think, do we have an echo? Okay. My first response to your point is that Singapore is deemed to be a reciprocating territory where India is concerned, and we do have a treaty. So and the SICC is a division of the General Division of the High Court of Singapore. So it's a part of the Superior Court system. So any of the money judgments out of the SICC may be registered in an Indian court and thereafter have the same powers as that of the local judgment debt. So that's the power of the treaty that we have where India is concerned, same with Sri Lanka and Pakistan within South Asia, as well as a few other jurisdictions that we have. So that's part one. Part two would be that beyond that, as you say, yes, in terms of enforcement of SICC judgments, it is not so much that it is inferior to New York Convention, I would say, but I don't want to spend too much time on it. But basically to say that we have three methods of enforcing an SICC money judgment. The first one would be the treaties that we have. The second one would be the Hague Convention on Choice of Court Agreements, that I think everyone's familiar, which deals with all the 27 EU countries as well as UK. They've since ratified it, together in Mexico, Montenegro, and the US, China, Ukraine have signed it but not ratified it yet. So that one where you state the SICC as a jurisdiction over this dispute, then it is enforceable within those jurisdictions. The third one is where enforcement has been all the while. And as you alluded to that, action by summary proceedings, where you bring proceeding before a court in that jurisdiction to say that you'd like to enforce it. Common law courts, you always have 4 defenses that the judgment debtor could use. One is that whether the SICC had competent jurisdiction. The second one was the judgment derived through fraud. Third one was the judgment debtor accorded natural justice or due process. And the last one is it against a public policy of that country? If it's not, then the judgment debtor has very little defense against recognition enforcement on the money judgment. Civil law jurisdictions, again, is a principle of reciprocity or committee. And for most of the civil law jurisdictions, where the strength lies, especially, is where parties have agreed mutually to submit to jurisdiction of the SICC. There's very little that a civil law judge would look at it and say, why are you then now challenging the judgment debt that arises because you had agreed to submit to the jurisdiction of the court? So that's where we see, in the interest of being totally open, there will be a few jurisdictions where they would not recognize it. One example would be Indonesia, where they still follow the old Dutch code, where foreign judgments are never recognized in that sense, right? So except for that, there's not an issue of having recognition enforcement of SICC money judgments in most jurisdictions around the world. So I'll leave that over there, Sheila, in the interest of time to move on this.
Thanks, Laurence. Wong, I'm afraid I won't let you move on because I've got one more question for you that actually relates to a comment by Tom as well as Vyapak about the international judges. The sort of composition of SICC judges being international obviously is one of the great benefits. And we heard, judgment of Justice Reyes, Justice Sikri from India. And indeed, if you just go to the page like I did and look at the profile of the judges, quite blown away at just how international it is. Of course, whilst that's one benefit, how does the SICC, Laurence, if you can speak to that, ensure that there is some degree of consistency or uniformity in the approach of their sitting as SICC judges? What are the ways in which they might try to achieve that?
Okay, now, since you brought it up, Sheila, so we have 16 international judges on our bench, besides the local judges that we have. From both, we have Dominic Harsher, who's still on the Court of Cassation in France, from a civil law perspective, and we have judges from England, from US, from Canada, Australia, Hong Kong, in that sense, Justice Reyes, formerly from Hong Kong, and of course from India. Right. So when we've had cases, and when you look at the judgments that's been written in some of our matters, you also see that what has been the advantage that it has brought a different perspective, it has brought a wider perspective to this. And if you can, not so much that, but even before judgments delivered, there has been discussions between the quorum. For some of the matters on first instance, we actually have either a single judge quorum or a 3-judge quorum. And for the Court of Appeal, we've also had international judges for SICC matters only sitting on the Court of Appeal. And there was a landmark judgment, Court of Appeal judgment, where the Chief Justice actually appointed a 5-judge quorum to hear that one. And that was on the cryptocurrency matter. In fact, one of the few cryptocurrency matters in the world. And I believe that the SICC set a very unique jurisprudence onto that, where you talk about the concept of mistake and with programming, and that's never been considered before. So that's where the interesting part comes in, where the SICC comes in. Having dealt with matters like that, we've also dealt with matters on ISDA master agreement that's come through the jurisprudence. So yes, even though the SICC is a relatively young court, but out of all the written judgments that we've delivered, there's been some really interesting ones, and that's gotten both in-house counsel as well as lawyers talking about it. So that the consistency is where, even though we are a common law court, I would say that depending on the governing law of that contract, we've even considered contracts where governing law is from civil law jurisdiction, and we've been able to address that in a consistent way, because at the end of the day, we think about it. What in every dispute, what are the two things that matter? What are the facts of the dispute, and what is the applicable law? And based on that is where the SICC stands in terms of an international perspective to dispute resolution. I guess the same as you could say where international arbitration is concerned. You always address what the facts are and what is the applicable law to this. So I hope I've answered you on that, Sheila.
Yes, thank you, Laurence, Wong, you have. And what I want to do is get Laurence, take your perspective, obviously as a long-standing practitioner and arbitrator here. Do you think Laurence Wong's answered the question, and do you have anything to add to that?
I do. I think that for me, one of the most important things is the presence of a Singapore judge on most, if not all, panels of the SICC court. What you get, I think, in terms of consistency, is that the form of the judgment, the procedures, all will be in accordance with what parties have come to expect from the Singapore court. But content-wise, and this is where the SICC, I feel, really shines, is that whatever the applicable law is, the expectation is that the tribunal that's empaneled would be able to speak to that law. It could be civil law, and there could be a lot of good faith issues, which are an overarching element in civil law, or it could be a common law. But the expectation from the market is and will continue to be that the best panel possible that can speak substantively, not just to the facts but to the law, will be impaneled. And then you get a consistency in the sense that there's a meaningful resolution in every case. Also, I'd like to mention, in addition to what Laurence Wong says, that from my time on the Rules Subcommittee, there was a keen sense that the procedures ought to be flexible. When it comes to civil law disputants and civil law lawyers, the expectation could be somewhat different to a common law litigation climate. There could be less discovery, less cross-examination, more reliance on documents. And the converse would be true in a common law arena. And the work of the Rules Committee was very sensitive to that. And again, that was to promote as meaningful as possible a resolution in any given situation. Sheila.
Thank you, Laurence, and both Laurence's very, very useful perspective, particularly your point, I think, about the non-Singapore law and the combination of judges to respond to that, what would normally be a foreign law submission. I think that's a very, very interesting and useful feature, as you rightly pointed out. I have one or two more questions, and just before I move on, I just want to remind our wonderful audience that obviously you do have the Q&A. You can join me in putting questions to this panel by using the Q&A function. Again, I have some questions and I'll continue, but of course I can also refer questions that you want me to from the box. So with that, let's pivot back to the funding aspect and what the availability of funding means in international court litigation. Now we have a better understanding of this particular international court. The question I have, and I'd like Cameron, if you don't mind, to address it first, is third-party funding usually only deployed by clients with financial difficulties?
I think traditionally it has been, yes, and it's partly because maybe that's how we as lawyers sold it to them. But there's been a bit of a change, and again, partly because that's how we are now informing clients about it. We would tell all of our clients about the availability of third-party funding, regardless of our perception of their financial standing. because there are some who would just like to get the costs off their balance sheet or control costs or for whatever other reason. So I think that the perception is changing, and I think it will be something that becomes maybe not quite a norm, but particularly with clients who are accustomed to disputes, construction companies, maybe insurance companies, it's just another part of their business and they need to control costs.
Thanks, Cameron. And Tom, from your perspective, and I know you mentioned this right at the start, but tell us what you think. What types of clients come to you or should come to you when looking for third-party funding?
Well, I think I'd absolutely echo Cameron's comments. I think historically, our form of finance was there to support impecunious parties, but we really have seen a shift away from that in the last 10 years or so. And we're in a situation now, and especially so in Asia, I would say, where the majority of our clients are usually actually quite well-resourced. They're sophisticated businesses. They see this as a corporate finance tool. And they're using it not only to manage costs, as Cameron said, but also just to manage risks associated with complex international disputes, which are very expensive. Or otherwise, they're just seeking to use our finance to leverage the value in their contingent claims. There are some instances where we not only fund the case itself, but we're providing additional advances on the claim value for the benefit of the business. And I mean, it's true in Asia, for example, we're working with regional and international MNCs, as well as smaller and medium-sized businesses. We work with listed companies, we work with SOEs, we work with financial institutions, insurers. They all have differing needs and differing risk appetites. Sometimes we're funding just a portion of the case, not necessarily all of it. I'd say the deals we do with these sophisticated clients are increasingly bespoke, but that's certainly the growing trend in the industry. It's what we're seeing and what we're doing most of the time.
Thanks, Tom. That's really interesting to hear. And in particular, just how, the sort of breadth of clients that can consider funding. I think the point Cameron made resonates with us as well, as normally the starting point was right back in the day, those who felt they couldn't afford it would start to think about funding. And now it's actually a much more complex and interesting question than that. Actually, just keeping to you, Tom, if you don't mind, I wanted to ask you how you mentioned costs, and cost has come up a few times. How do you manage liability? So, there's been a lot about adverse cost orders. Can you give us some insight into that from a funder's perspective?
Sure. Well, adverse costs is part of the risk in a case, and it's often part of the risk that clients are looking to offset as well as their own costs. So it's very common for our funding arrangements to include some sort of cover for adverse costs. We typically do that directly. Some other funders will do it in the form of a distinct insurance policy and after the event or ATE insurance policy that covers that aspect. Where it becomes quite interesting, I think, in the context of proceedings is where the issue of security for costs comes up and perhaps how we deal with that. And there's been a lot of debate in the arbitration world about how you do that, because arbitral tribunals don't necessarily have jurisdiction over a funder and therefore can't necessarily make an award of costs against them. In those circumstances, where security is required, we will often give an undertaking to pick up any award of costs against the claimant, and in some situations we'll submit to the jurisdiction of the tribunal on that question. It'll be interesting to see how that plays out in the SICC, because it's a court and it could in theory make an order against a third party. It wouldn't necessarily need us to submit to the jurisdiction, and in theory it could make an award against a funder for facilitating proceedings, even if that funder hasn't agreed to take on that exposure, which is quite an interesting and different dynamic to what you see in the international arbitration space. So it will be interesting to see how that plays out.
Thanks, Tom. I think that is a very key point, and one that clients tend to focus on, obviously, as an active point. And in particular, the amendments to Order 110 really speak to that very accurately. So yeah, thank you for that perspective. Just speaking of rules and the SICC rules, of course, Laurence, Wong, can I ask you, and I'm conscious we're just at 1:30, but this is my last question, I promise. Well, I think so anyway, I'll hold back on the promise. But Laurence, Wong, can I just ask you to explain what the upcoming SICC rule amendments will look like and bespoke benefits that we as potential SICC users will see?
Sure, Sheila. And Tom, I guess a quick one. I'm also just as eager to see what happens as we bring in third-party funding and how the court looks at various aspects of it, including adverse costs. So, Sheila, yes, we will eventually change Order 110 of the current rules of court and spin it off into its own separate SICC rules. I think that has been in the public domain for a while, but the exact timing and date is something that we need to think about. But why we're doing this on the new SICC rules is for 4 general principles. The first, expeditious and efficient administration of justice according to law. Second one is procedural flexibility, which is something that the SICC has prided itself on, in a sense that even though we are a common law court, we've had procedures that are very uncommon for a common law court, I would say. The third principle, we want fair, impartial, and practical processes. And the fourth one is procedures are compatible with and responsive to the needs and realities of international commerce. Now, why we've done all this, if you really think about it, is that the SICC was founded on 2 key principles. The first one was strong international commercial law, and the second one, which we've done in the sense of some of the jurisprudence that we've sort of developed over the last 6 years. And the second one is on international best practices. So it is what many of the commercial lawyers, like this entire panel down here, would like to see in terms of efficient procedures. And we've taken that and tried to bring it in. I mean, for example, we've done away with general discovery. We allow application of different rules of evidence, and also the right to appeal, or even the doing away with the right to appeal. So these are the sort of things that we've done, and that's to bring it all together. If you really think about it, while we talk about it, it has always been, in a sense, arbitration in litigation, such that whether you're an international arbitration lawyer, you coming into the SICC for the first time, you will not find yourself unfamiliar with the court proceedings, number one. Number two is also that all the procedures that you've had, whether coming from a civil law or common law background, as Laurence had alluded to earlier, it's also familiar in that sense, because one of the bespoke new SICC rules in that sense is a proposed amendment where at the first case management conference of a matter before the court, the judge actually has a discretion to direct the case proceeds along one of 3 tracks, either through pleadings, as many of the common law lawyers are familiar with, or pure statements, or even memorials, which is something that the civil law practitioners are more familiar with, and also that's you can find in international arbitration together. So that's where we're coming about in order to have the new SICC rules and how it evolves based on those 4 principles. And I think, as I said, that's going to be exciting times. The first case was today's session, where third-party funding is now available. And I think that's really made Tom's day, in a sense, last week when the news came out on that. So I'll leave that as that, and basically watch the space where the SICC is concerned as a dispute resolution forum.
Thanks very much, Laurence, Wong. Before I wrap up, I'm just going to ask if anybody else on the panel wants to comment on that, or indeed any other aspect of what we've discussed today. Great, you're a very diligent panel, I must say. I just wanted to thank you as the panel in particular, but also, of course, our wonderful audience for listening to us this afternoon. I want to end by picking up on a point that Cameron made right at the start, in that I think you have become the panel of disruptors, and I think we'll have got our audience to pull out their templates and rethink what it says in the Dispute Resolution Forum, particularly now as it opens the door even more widely to third-party funding. So with that, thank you, everyone. Apologies, we've overrun by a couple of minutes, but thank you so much for bearing with us. Thank you very much to the panel, to the SICC, and also, of course, to everyone who's participated. And have a lovely rest of your day today. Thanks very much.
Thank you, Sheila, and thanks all.
Thank you, Sheila. Thanks, everybody.